competition law. Today, he would be speaking and enlightening our students on the topic of Google versus on the recently decided Google versus Oracle. First of all, before he begins his session, I would request Dr. Rekha Kumari Singh to welcome today's guest of honor.
Thank you, Guru Raj. Firstly, I would like to welcome all of you in this webinar, and I take honor and privilege to introduce our guest and speaker of today's session, respected Professor Dr. Shubha Ghosh, sir. Sir is a Crandall Melvin Professor of Law and Director of Syracuse Intellectual Property Law Institute. Sir has earned his JD from Stanford University with distinction and his PhD in economics from the University of Michigan. He earned his BA cum laude from Amherst College, and prior to joining Syracuse University College of Law, Ghosh sir taught at the University of Wisconsin Law School as a chair tenured professor and co-director of the Innovation Cluster, consisting of faculty in the Law and Business School. Sir has joined Syracuse University of Law in January 2016 as a Crandall Melvin Professor of Law and Director of the Technology Commercialization Curriculum Program, a unique program which trains the students in intellectual property, business law, and the legal foundation for the commercialization of patents, copyrights, trademarks, and other legal property governing technology innovations. A member of the California Federal Circuit Bar and U.S. Supreme Court Bars, Ghosh sir was elected to the American Law Institute in 2012 and is currently a member of advisory board on the restatement of the copyright. Sir has been an IIP Research Fellow in Tokyo and Fulbright Fellow to India and a recipient of a National Endowment of the Humanities Research Grant. Sir has authored and edited several books and monographs and also participated in several international conferences, both as presenter and a chairperson. Sir is one of the most eminent scholars who knows extensively in the areas of intellectual property as well as competition law. And I'm really proud that on behalf of Anand Law College and Anand College of Legal Study, Sir has accepted our invitation, and I'm also glad to convey special thanks to Guru Raj, Mr. Guru Raj, who has coordinated and made this happen for today's seminar. So, on behalf of both the organization, I welcome you, sir, and session is yours, sir.
Thank you very much. Good morning to you, everyone. This is quite an honor to be able to speak to you. So the only disappointment is that it's being through Zoom, but this is the situation we're in. I wish everyone well. I am keeping informed about the news in India, and I wish everybody a speedy recovery and speedy control of this disease. I hope everyone is doing well. Thank you, Dr. Singh, for the overly generous introduction. Namaskar, thank you. And thank you for the invitation. I hope I can give you and share with you in the next hour some thoughts about the Google versus Oracle case in the U.S. Supreme Court from, I think, basically 2 weeks ago. It's a case that was watched very closely and has some very interesting implications for copyright law, as well as for the software industry, not just simply in the US, but globally. In many ways, it's very awkward to talk about the case because it's a uniquely US case. It deals, the final decision from the US Supreme Court deals with the fair use doctrine, which is, hope in our discussion we'll see is a very unique US doctrine. It's distinct from fair dealing. and really has been a source of some controversy as far as whether it's even compliant with the TRIPS obligations. But I think it is. I think it's an important exception or limitation within copyright law, but also something that gets to the very heart of copyright law regarding the incentives for creativity and also for the development of different types of industries, whether we're talking about software, whether we're talking about music, whether we're talking about publications and so forth. So the Google versus Oracle case, as the names of the parties suggest, shows that the case deals, in a very narrow way with the software industry. This is a dispute that went back to 2010, but has to do with the development of the operating system for the Google Android smartphone, which Google developed using the Java-based operating system. And Java has been around for quite a bit of time. It's been integrated in many different types of platforms. When Java was developed by Sun Microsystems back in the 1980s, if not earlier, it was deemed to be open, whatever open might mean. It wasn't open source per se, but it was meant to be available for interoperability so that different programmers can develop different packages, and they would be there would be very little obstacle across the various types of platforms in terms of either the sharing of applications, the use of applications, and so forth, as well as within the Android system, systems like Android, which are more open source than, for example, the OS system on iPhones or other types of devices. I think the Sun system, the slogan, I may not be remembering it correctly, was something like program once and then use often. Now, what makes this interesting is that Sun was purchased by Oracle, and then Oracle took a very proprietary view about the Java system. And the issue here, of course, is that Google was making use of the Java system, but it was only making use of a certain part of the system. And so this is where we get into some aspect of computer programming. The way in which we think about computer programs, and some of you may have familiarity, I do some programming. I imagine many of you probably do more coding or programming than I do, or have more familiarity than I do, but I've been learning a little bit of Python, and I've worked with Java in the past, largely for my own curiosity. And with Python, it's been more research oriented because it's a very powerful tool. But within any type of software package, if you will, such as Java, um, you have different types of libraries. And again, there's lots of different methodology, lots of different language. And so the language in this case can be very confusing. But within the case itself, and what the Supreme Court looked at was something called the Application Programming Interface, or the APIs. And we can think about the APIs as a set of libraries that would have certain types of functions that are, if you will, pre-programmed. And these then pre-programmed libraries could be called up for those who are using Java, and then they can build their own additional software packages, software programs, based upon those basic libraries. So we can, there are many analogies that have come up with this, but we can think about this maybe as an orthographic system or a linguistic system. So if I want to write something in Hindi or Bengali or Urdu, we have to have certain basic characters. and those characters will call up certain sounds, and then the sounds can be connected to create words. Then the words can be put together to create sentences, and so on. And so the application programming interfaces, that language, again, it's a very confusing language, and perhaps we can discuss this in Q&A. But the APA would be the equivalent of the letters, the equivalent of the words. It may even be equivalent to the grammatical structures that comprise the language. But then how those things are put together would be then constitute, the song, the book, the essay, the novel, the article that we would think would have copyright protection. And so I'll use the word API, but the other language or the other terminology that comes up is declaring code and implementing code. And declaring code would be the example of the letters or the words. So I, will have a certain character, for the sound all or the oral sound that I can declare. And then I use that symbol to declare that sound or that phoneme. And then that would be part of a word that I can also declare that uses those symbols. And then I can use that word that I've declared into something called an implementation. And this is the language of implementing code that then becomes the sentence or the paragraph and so forth. That would be the subject of the copyright material. So in this description, I've tried to give you a sense that these APIs or these declaring codes are just the building blocks. And these are the ones that would not be part of the copyright protection. And the implementing code would be potentially copyrightable if it meets other requirements such as originality and subject matter and so forth. And so the Supreme Court's decision and the way this case was argued, sometimes you see the discussion regarding interfaces, so you see that language. Other times you see mention specifically of declaring codes. And even when I was reading a brief authored by computer scientists that was submitted to the US Supreme Court, they talk about the API having different components, and they talk about the API consisting of both declaring code and implementing code. So I'm not a computer scientist. I do programming, as I mentioned, but some of the language is a little bit confusing, and I'll try to clarify as much as possible. And then as we discuss as to what the legal implications are, we can go back and think about this underlying computer science terminology. So if you take the example, how does this then apply to the Java SE, the Java system on which Google was building its operating system? What we think about is declaring code, as I mentioned, were certain libraries within the Java system. And these, I don't know if I can share my screen. I don't want to, I don't know if people can see it. I did have some items. I'll try to see if I can share my screen. Am I able to share my?
Yes, sir, you can share.
Okay. Can everybody see this then? This is a page from the, so everybody can see this. There's a paragraph that says a methods declaring code can be lengthy, and everybody can see that?
Yes, sir. Yes, sir. It's very much visible.
Okay, good. So this is a page from a brief that was written by computer science professors on behalf of Oracle. So it was actually on the losing side. They were arguing against fair use and in favor of full copyright protection. But the brief does a good job in describing, what these declaring codes and interfaces are. And here's an example of the language, which would be the declaring codes. What this language is doing as it's part of the Google operating system is it's basically calling these different libraries. I don't know what these specific libraries are. We can discuss them if you know, you can clarify. But this portion of the code is what's being declared from the Java system. And then once these declarations occur, they get integrated into the full Google operating system, which will be several millions of lines. And the declaring codes were more than this as well. I think there were about several hundred lines or so. But the point I want to get across is that you have these types of declaring codes that are integrated in the full computer program. The portion here that's deleted or that's omitted are the implementing codes. I don't have a good example right now of what implementing code looks like, but what the implementing code would be the actual language that would be taking some of the functions, some of the things that are defined here, and then integrating it into whatever the operating system program is doing. So to give you an example of what these libraries look like, I like this figure here that basically talks about different types of functions. The draw circle, the draw ellipse, draw square. And so instead of Google rewriting the program, the underlying, its own declaring, let me put it this way, I won't use the word declaring code, but its own program that would be able to draw a circle or draw an ellipse or draw a square, it would then take the declaring code, the underlying libraries that would have its own way of declaring, drawing a circle or drawing an ellipse or drawing a square, and then implementing it into its own operating system. And so if you look at, for example, what the code might look like for a display, the display, which might, show a table, it might show a text, it might show email, would consist of these basic images and several other ones. And then these would be combined in some way through the implementing code in order to create the more complex images that would be part of the program. So these are the kind of distinctions that that are at the heart of the Google versus Oracle case and make it very interesting. This case originated 10 years ago as a patent dispute. And so these raised patent claims regarding underlying patents for the software. So there is a subsidiary issue regarding the patentability of software, which again we can discuss in question and answering, because that's also a subsidiary issue. But this originated as a patent dispute regarding patent protection for the software. But Oracle, in addition to the patent claims, raised the copyright claims because it argued that there was copying of these APIs, specifically the copying of these declaring codes. Now, the district court, I don't remember the full procedural issue, but the way in which these arose procedurally, but at the district court level, the patent claims were found to be invalid. So the underlying patent dispute basically went away. There were some questions about the actual validity of the patent, but the copyright claims persisted. And that can be very interesting in terms of how that set up the mindset on appeal and the way in which this case was argued. But the district court also ruled that these declaring codes are not protected by U.S. copyright law. They were deemed to be actually not soft. I mean, it's very interesting, the argument. One argument, of course, was that they're not even code to begin with. That when we think about software code, we actually are thinking about a set of instructions that are then developed by the programmer. All these declaring codes were, according to the district court, was not actually a program, but just simply calling these other programs that were part of the Java system that was being used here. So you can analogize this to saying, it would be like protecting the words in a language. The words in a language are not protected by copyright, the way in which the words are put together are protected by copyright, of course, if they meet the originality and other requirements. But the district court was saying that the basic underlying declaration codes or APIs, whatever the unit of analysis might be, was not even protected by copyright at all. And so this issue did go up on appeal to the Federal Circuit, which is a specialized court in the US for intermediate appeals. The Federal Circuit was created to deal with patent appeals, but it also can deal with copyright cases when the copyright claim is raised along with a underlying patent claim. So here you have the Federal Circuit, which is not a copyright court. I want to emphasize that. Basically, ruling on the copyright issue. Again, I don't want to get too much into lost in the procedure, but I'd be glad to take the any questions about this. But this is actually, I think, a very important point to understand a little bit about the U.S. system and why so much of this, so much of this dispute is very specific to the U.S. But what the Federal Circuit ruled, when the Federal Circuit rules on its patent appeals, all patent appeals have to go through the Federal Circuit. So the Federal Circuit has its own body of patent precedents, and it's bound by its patent precedents. However, the Federal Circuit is not the only court, intermediate appellate court, that hears copyright appeals. There are appeals that go through the Ninth Circuit, they go through the Second Circuit, and each of these circuits are demarcated by a group of states on which the underlying initial claim originates. So whenever the Federal Circuit has a copyright appeal, what it's supposed to do is go back to the actual circuit and the precedent within that circuit from which this case originated. So the Google versus Oracle dispute originated in California, which is part of the Ninth Circuit. And so the Federal Circuit would have to have followed Ninth Circuit precedent on this issue regarding APIs and declaring codes and so forth. And generally, the Ninth Circuit's view has been to be more in favor of fair use and for limited protection for software copyright. However, the Federal Circuit did not follow that approach. Again, when we're thinking about how these appellate courts operate and how they use precedent and how they construe precedent, this is something we could spend a lot of time discussing. But the Federal Circuit's view was that this was all copyrightable, and they follow the logic that there is some degree of creativity in writing any type of program, including declaring codes and so forth. And therefore that should be given protection. And in this appeal, I mean, this is where it gets very interesting in terms of how the case was argued. When I showed you the APIs before, the declarations before, and the district court's view that these weren't even code, but the Federal Circuit did not view it that way. In fact, Oracle's attorney on appeal was really pointing to the fact that this is code, and this is really the thing that was copied by Google, and therefore should be given full copyright protection. And so this is lots of very interesting details here regarding how this case was argued, but the Federal Circuit initially overruled the district court. There was an appeal to the Supreme Court at that point, but the Supreme Court decided not to take the case at that point. I think this was about 2014 or so. I forget the exact date. And so this means the case goes back to the district court, the trial court level, and then it goes to full trial. And there was a finding regarding fair use by the jury to say that even if this was copyright protected, Google's use of the declaring codes was fair use. That then gets appealed to the Federal Circuit. The Federal Circuit again overruled, basically saying that this was not fair use. As a matter of law, Google had taken too much. We'll get into the fair use factors in a little bit when I talk about the Supreme Court decision. And then basically there was infringement. The fair use defense did not work. So it is on this ruling by the Federal Circuit that the Supreme Court granted the cert review. It basically opened it up to review the full record of the case, going back to the very beginning, going back to 2010. And the Supreme Court initially focused on the question of copyrightability. Are these software programs, this declaration code APIs, copyrightable? And the argument was slated for hearing. I believe the exact date was March 23rd, 2020. I remember that date. I may misremember now, but the date is somewhat fresh in my mind because I was booking a flight to go to the oral argument. But this is March 23rd, 2020, the week before quarantine, shutdown. And so the Supreme Court canceled its oral argument and was going to reschedule it and so forth. I canceled my trip. I basically have not flown or traveled since March of 2020. But in any case, that was the original date for the argument, and they had rescheduled it. But one of the things that the court did, however, after it canceled the first hearing, was to request further briefing on the fair use issue. So originally they were only going to focus on the copyrightability issue, but then for whatever reason, we can discuss a little bit of what the dynamics of the court might have been. They asked for further briefing on the fair use issue, and there was extensive briefing then submitted in late spring and summer of 2020, and the actual oral argument was then occurring in October of 2020. I think one of the first cases, the court meets the first week of October. That's when the term begins, and so this is one of the first cases that they heard. And one other development that should be mentioned here, that everybody knows from news, is that when the court was granting the cert and asking the briefing, it was a court of 9 justices, including Justice Ruth Bader Ginsburg, a leading copyright justice, and she passed away in September of 2020. And everybody, I think, followed the various antics in order to try to fill her position as quickly as possible before the 2020 elections. Is very kind of a very unfortunate set of circumstances, in my opinion, in terms of the rush. But in any case, when there was oral argument, it was in front of 8 justices rather than the full 9. And that caused some people concern because with 8 justices, of course, there's a tie, possibility of a tie. And the court had heard a similar question regarding the different types of interfaces, but generally in the software copyright space back in 1995 in a case called Lotus versus Borland, where the lower court had found that the menu command hierarchies in the Lotus system was not copyrightable. And so then the Supreme Court had granted cert, but for various reasons, one of the justices, Justice Stevens, could not participate in the oral argument because of some conflict of interest. So that decision was 4-4. And this has been one of the interesting lost opportunities, many people think, in copyright law for the Supreme Court to get a very early ruling in the 1990s in this general area of software copyright. So once a Supreme Court ties 4-4, then the lower court ruling just stands. And so that's what people are wondering now. Will that happen again in the Google versus Oracle case? Will there be some sort of tie, 4-4? In that case, there might have been an argument for another rehearing in front of the full court because of the unusual circumstances of Justice Ginsburg passing away. She was there for the granting of the cert. but then passed away. So there would have been an argument that even if it was tied, that there could have been even a third rehearing of the case. But we didn't get to that. In April of this year, the Supreme Court ruled 6-2 in favor of Google. And let me talk about that decision now and talk about some of its implications. The first thing about that decision was that the court did not address the copyrightability issue. Within U.S. copyright law, there is an exception under Section 102B that certain things cannot be copyrighted, and those include methods of operations, ideas, systems, procedures. Under 102B, these are deemed to be functional and outside the scope of copyright, and if anything, within the scope of patent law or trade secret or maybe some other body of law. And so the Supreme Court decided not to address the 102B issue. It was argued, but we can discuss why. I think there's some interesting reasons why it didn't do so. But it said, let's just assume that these things are copyrightable. And so even assuming that they are copyrightable, we do think that Google's use of these pieces of code, the APIs, the declarations, were fair use under U.S. copyright law. Before I get to the fair use discussion, let me compare this with how the EU has handled this. There's a case called SAS, the SAS case, which the European Court of Justice ruled on in 2012, having to do with interfaces, somewhat similar to the issue here. And this is one of the big problems I find in the software copyright cases is just the description, but they deal with interfaces. But the court's ruling, the ECJ's ruling, was that the purely functional features of software are just outside the scope of copyright, within the language of the copyright directive, within the language of TRIPS, within the language of national copyright laws. And they, even though they don't have directly the equivalent of a 102B within copyright principles, these things were excluded. The Supreme Court declined to do that, for reasons we could discuss. Maybe they felt it had a stronger ruling on the fair use and could make a more interesting impact on fair use. But they decided to pursue the fair use, which, as I said, as I described, a uniquely U.S. doctrine. Fair use goes back to the 1840s. It was a judge-made doctrine. It was described in its original incarnation in a case called Folsom versus Marsh as a privilege. So it was a defense of privilege, a privileged use, a certain type of use that was justified under the circumstances of the particular use. And I want to emphasize the word use because it is focused on that. And the question is, whether the use of the work would interfere with the copyright that the owner of the work that was being used held. So the inquiry of fair use looks at both the use and the work. And it looks at both somewhat broadly and somewhat contextually in order to determine whether a fair use determination should exist. Now, the Folsom versus Marsh case, I think is a very interesting case. We could spend a whole seminar just talking about that case. An issue in that case had to do with the letters and papers of George Washington that had originally been published in a 20-volume set. I think it was 20 volumes, so a very large set of books. And someone had created a condensed or an abridged version so that they were distributed in a 3-volume set. And so the question was, would that be a justification or a privileged use of the copyright? So even though Folsom versus Marsh discusses and introduces this notion of fair use, In that particular case, the court did not find fair use. And the kind of analysis that the court sets up is to look at four factors. And the four factors are now codified. They were codified as of the 1976 Copyright Act in Section 107 of U.S. copyright law. And the four factors that the court must consider are the nature of the purpose and character of the use. So what exactly is the use for? Is it for research? Is it for education? The nature of the use, the nature of the work. What type of work is it? Is it a fictional work? Is it a non-fictional work? Is it a creative work? And so forth. The amount taken, so how much of the work was actually used, and that's both a quantitative and a qualitative inquiry. And then finally, the fourth factor, which is the impact of the use on the market of the copyrighted work. Now, all of these four factors are supposed to be balanced. They somewhat are deemed to be co-equal. In practice, when you're looking at fair use, often the fourth factor tends to be the most critical. But the courts typically work through all four factors and think about them contextually and holistically. And so, for example, in the Folsom versus Marsh case, the court does look at the nature of the use, which was the purpose and character of the use, which was an abridgment. And it does acknowledge that in English common law, abridgment was allowed generally. But it also looks at the nature of the work, which was non-fictional letters from George Washington. So they had historical value, but they were not imaginative works like a novel. As far as the amount taken, here this gets very interesting as far as how you calculate the amount. As I mentioned, it was abridging a multi-volume set, about 20 volumes down to 3 volumes. So you might argue that maybe not much was taken, but the court basically focused on the fact that as far as the individual letters were concerned, the abridger had copied the full letters, the full texts. And so they found from a qualitative standpoint, as well as from a quantitative standpoint, depending upon how you're looking at the denominator for the quantitative analysis, that a lot was taken. And so that factor weighed against fair use. And then finally, the court in that case says that the abridged volume would affect the market for the full set of letters, and that would be harmful to the copyright owner. And therefore, when all the factors are looked at together, they are found against fair use in Folsom versus Marsh. So Folsom versus Marsh goes to the middle of the 19th century, and as I mentioned, fair use was codified in U.S. law in the 1976 Act, which was effective in 1978. So that's 150 years. What happened in that interregnum? There was fair use. The court, applied fair use, but as a kind of a judicial doctrine. A lot of discussion about whether it's a defense. As I mentioned, it was discussed as a privilege, so as a type of justification for copyright infringement. During that 150 years, I won't go through obviously all the various cases. They're very, very interesting cases that arose during that period. The main language that we see, though, that comes out of that period is that fair use is meant to be an equitable doctrine. So we get into this question about, what does equitable mean? We know equitable means fairness, but we also know from the history of common law that the courts were divided into the courts of law and the courts of equity. And that distinction was done away with in the U.S. in the 19th century, in the federal, both at the federal level and then pretty much at all the state levels as well, that we have general courts that don't distinguish between courts of law and courts of equity. And so there is an interesting question, what does it mean to say it's an equitable rule? Typically, when you say a rule was a rule of equity, back in English common law, you meant you had to go to a specialized court. Of course, that's not what we mean now when judges refer to fair use as an equitable rule. They mean it's one where the courts are not limited by the legal, the statutory language. It's meant to be a rule of fairness. It's meant to recognize certain exceptions to copyright law, within the parameters of fair use as laid out in the then common law. And now it's been codified. So there's some very interesting question about whether once it's codified, how much the equity persists. But if you look at the fair use cases under the statute, so the fair use cases post 1978, this language of equitable rule keeps coming up, and it certainly comes up in the Google versus Oracle case. So for the fair use decision in Google versus Oracle, the first thing to notice about the decision is that it begins the analysis with what's generally considered the second factor. So the four factors I mentioned from Folsom versus Marsh are codified 1, 2, 3, 4 as 1, the purpose and character of the use, number 2, the nature of the work, number 3, amount taken, and number 4, the impact on the market. Very, very brief summaries of those four factors. And typically a court will go through them in order, 1, 2, 3, 4. In Google, the Justice Breyer's opinion begins with the second factor, the nature of the work. And this is very interesting. It's got a lot of attention. Why are they doing it out of order? One of the reasons they're doing it out of order is now that the court now addresses this issue of functionality of software in the second factor. So when they're talking about the nature of the work, the court says this is software. Software we recognize can get copyright protection, but it's also functional. And so even though if the court evaded the issue of functionality as a matter of copyrightability, it recognizes it with full force in this analysis of the second factor, which is, of course, the first factor that it turns to, looking, not following the order of the factors of the statute. And so it finds it functional. It finds that these declaring codes and the APIs are functional. Again, this is where we get into some question about the language. What is it talking about? Is it just simply talking about things that are identified as declaring codes? Is it talking about APIs more broadly? Is it talking about another category called interfaces, much like the European Court of Justice did in the SAS? I think, from these cases that are emerging, especially the Google case, this is one of the big open questions in my mind. How broad is the decision? I would read, when you look at the analysis of the second factor here, the court is talking about any functional feature of software, whatever that functional feature might be. And so even though it's not defining, what that might be under 102B, it's recognizing that there are functional features of software, and therefore we need to acknowledge them. And those are the things that Google made use of here. And, this is a very interesting rhetoric. I think just from a pure rhetorical standpoint, it's interesting. The dissent, this is Justices Thomas and Alito in dissent, really took the majority opinion to task here, because, they're saying, on the one hand, you're saying you're assuming copyrightability, but then your fair use analysis, you begin by taking away copyrightability by focusing on function, which is not copyrightable under 102B. Why are you doing this type of subterfuge and so forth? So we can discuss that in Q&A, but it's a very interesting interplay. And so once the court identifies these functional features, it then goes through the other three factors. As far as the first factor, the purpose and character of the use, what the court is saying is that Google was trying to basically create this Android operating system that built upon Java And it was trying to do this because other operating systems also, such as the operating system for the iPhone, also used Java, and therefore this allowed for interoperability. And therefore, the purpose and character of the use was to allow for this interoperability, this compliance, this ability for users, cell phone users, to be able to take advantage of the networks with other cell phone users. And the other aspect that's very interesting that comes up in some of the other briefs, not the computer science briefs, but in briefs that are submitted by computer programmers, and that is computer programmers have invested much resources in learning Java, especially learning about the declaration codes and the APIs. And Java was initially designed as a platform that would try to promote interoperability. And therefore, from a programmer standpoint, independent of the cell phone user standpoint, but just purely from a programmer standpoint, and this is actually some part of the opinion that's fairly unique in this area of software. I haven't really seen other decisions that focus so much on the use by programmers. The court finds that there's value for the programmers to make use of this declaring code, much like there's value when you use words, letters, and so forth in writing something using a well-defined language. Okay, so that's the first factor, the purpose and character of the use, which the court, just to remind you, is analyzing second. And then it goes to the remaining 3 and 4 in order. Amount used, the court basically says not that much was used. Again, this whole issue of amount that was used is very controversial. I mean, Oracle's argument is that they used, all of the declaring codes that they used 100%, and therefore this factor should weigh against fair use. The court said, well, let's look at the amount of declaring code as a percentage of all of the code that Google wrote. And Google wrote millions of lines of code for its operating system, only 100 of which were actually from the declaration codes or the APIs in Java. And therefore, it's just a small percentage of the entire Google code. The rest Google wrote itself and created itself. Finally, on the fourth factor, the market, for the market impact on the copyright, the court really found very little impact. The court basically said that there was a practice about using these APIs. Sun had actually marketed these earlier as being open for people to use. But more importantly, the court is saying that what Google was doing here was taking the declaring codes and creating a completely different product that was not competing with Java. So this is where we see one of the important words that comes up in fair use analysis, and that is that of transformation. That what Google was doing here was some sort of a transformative use, and that's also relevant for the purpose and character of the use analysis for the opinion. But it was creating a whole new product. And this is where this case is very much aligned with other cases regarding software copyright. So there was an earlier decision, not from the Supreme Court, but from the lower intermediate appellate courts. So from the intermediate appellate courts, a case called Sega versus Accolade, where makers of game cartridges were making use of some aspects of Sega's operating system code in order to develop the game cartridges. And the court there was saying, well, these new game cartridges were ones that actually expand the market for Sega. And therefore, that's beneficial to Sega's market. And therefore, you have a transformative use that's creating a new product. In Sony versus Connectx, Sega versus Accolade is a case from the 1990s. from the 2000s, a very important case called Sony versus Connectx, in which you had a company that was using parts of the software in Sony's PlayStation in order to develop an emulator so that Sony games could be played on a PC. And again, the court there said that what the alleged infringer was doing was creating a new product that would actually probably benefit the market for Sony's games, and therefore that was a positive use, a transformative use, and that worked in favor of fair use. So that is the court's analysis. I think it's a very important decision. There are a lot of questions that are still left open, such as the copyrightability of software. I think this case is important because we're seeing software being used with so many different applications, and I'll just leave this as an interesting teaser for you to think about. 2013, the Supreme Court ruled that naturally occurring DNA sequences cannot be patented. And now you have this interesting case regarding fair use of software. And in the meantime, we're also seeing developments of new forms of drug therapies, as we're seeing in COVID. Both the Pfizer and Moderna drug were developed using software techniques as well as biotechnological techniques. So we're seeing a very interesting marriage of software and biotechnology, which raises some very interesting questions about how cases like Myriad, regarding the non-patentability of naturally occurring DNA sequences, will interact with cases like Google involving fair use of software. But the underlying question that still bothers me, I think is a very interesting question, is what exactly is being protected? We know it's the functional features of software, but it's an interesting question as to what do we mean by interfaces, what do we mean by APIs, what do we mean by declaring codes. I think the case is a lot broader than just simply saying that the copying of declaring codes from Java in order to create a new product like a operating system for a smartphone is fair use. I think that's probably the most narrow way in which you can read the case. But I think the ruling is much broader than that, given the language that you see in Justice Breyer's opinion. How much more broad is for us to decide as we analyze the case, discuss the case, and as the case gets further litigated, as cases like this, not this particular case, but cases like this get further litigated in the U.S. and other jurisdictions. I mentioned the connection with biotechnology potentially. Certainly, as we're seeing artificial intelligence becoming the subject of copyright disputes and patent disputes, I think this case might be very influential for how we also think about copyright and artificial intelligence. So again, I hope this was a good way to begin your morning. I hope you found the comments helpful. Thank you for your attention, and I look forward to any questions you may have, and I'll be glad to either clarify my comments. I hope everything came through clearly through the broadcast, but I would either be glad to clarify or take any other questions from the audience. So thank you very much.
Thank you, sir. Thank you for your enlightenment. And regarding this particular case, because I remember when this case was decided, I read this case, but it was a bit technical. So it was very good of you that you explained this particular decision in a very easy and lucid manner for our students. If any particular student has any query, he can ask, sir.
Shall you handle the question, or shall I do it, or how would you like to do this?
Sir, there are some students. Yeah, Ruturaj, a particular student, has raised his hand. Yes, Ruturaj, you can ask.
Hello. Yeah, I'm audible. Hello.
Yes, I
Yes,
can
you
hear
are
you.
Yeah. So my question was that as you told that on this four factor, actually the court has decided that the last one factor, that impact of the use of copyright. So,
Yes.
sir, that by allowing the other firms to use the Java system under the fair use system, won't you think it will reduce the motive for innovation within the software industry?
Well, I mean, this is a question of how broad the case is read. I think in a most narrow way, it only applies to the declaring codes. The court makes it clear that the implementing codes are are still copyrightable. In fact, I think to be even more fair, the court does not deny copyrightability. It says they are copyrightable, but it says this particular use is not infringement. So I think the effective incentives are probably not, they can be greatly exaggerated. Certainly the dissent felt that I think the dissent closes its opinion by saying that, following your question, that, this is eviscerating software copyright. I forget exactly the language they use, but they use the word eviscerate to suggest that the incentives are being taken away. I'm a bit more skeptical about that, partly because, most people thought the Federal Circuit's decision was the outlier. If you look what happened at other decisions regarding software, they've also been, they don't deny copyright to software, but they're very, they hold it as thin protection. And the software industry in the US has been thriving. We can question whether it could be thriving more. So I think the Federal Circuit decision was the outlier, and it may have caused, if it had been upheld, it may have caused more uncertainty. But to take your point, we don't know how broadly this decision was held, will be applied, and this is maybe explains another reason why the court, took a fair use approach rather than addressing copyrightability directly. I think if it had taken a ruling that declaration codes are not copyrightable per se, which is what some people thought they should do, then it does raise a question about, well, how broad is, I mean, what is that? What is it? As I've mentioned, this is why I wanted to emphasize that it's not really clear whether this is even a case about software at all, or it's just simply about these underlying structures like letters and libraries and things like that, the equivalent of letters in languages or grammar in language. So that's, I think, one of the reasons why the court may have avoided, this copyrightability issue. Now, if you look at the European Court of Justice, they do take on the copyrightability issue, but again, there is some question there about what exactly does it apply to? What exactly is an interface? And this is going to be an open question. I think there is enough uncertainty as far as translating the technical computer science and programming into law that what the effects on incentives will be subject to debate. But I mean, I think the case was fairly narrow, you know, generally. I mean, I think it's more narrow, it's broader than just simply about declaring codes in Java as used in operating systems. I do think it's broader than that. But I think the court was trying to be very careful in not upsetting the software industry too much. And what I mean by upsetting it, I don't mean making them mad. I mean, because I'm sure whatever they did, they would have made somebody mad in the software industry. I mean, in terms of unsettling the foundations for the industry and how it prospers.
Yes, sir, but there was one follow-up question that by this verdict of Google versus Oracle, will the small player who are just thinking for a new startup will get any impact?
Well, I mean, it depends on what the startup is doing. I mean, I think I think it's probably beneficial to startups to the extent that startups are relying upon Java and are relying upon these types of foundational aspects of code or building block aspects of code in developing it. But so that from that perspective, I don't think it's anti-startup. I guess if it's the startup, the next startup to Sun, that's the equivalent of Sun, that's creating its new uh, operating system. I don't know how many startups are like that. Then yeah, maybe there's some interesting question. I mean, there is this underlying question about what exactly is declaring code and implementing code. So there might be some interesting questions about what are incentives for programmers. Does that mean that they're less likely to create these libraries? Or, I mean, this is something I would have to talk to somebody, and maybe somebody in the audience can clarify, but somebody who has some knowledge of computer science or programming can say, well, maybe there's a way to write code so all code is implementing code. And therefore, the fair use analysis may not apply in the way in which the court, lays it out in this case, and the way in which, and even the way in which the ECJ deals with it in the SAS case. Are there follow-ups to that, or is that?
No. Thank you, sir.
Yeah, these are great questions. I mean, I don't have the definitive answer, of course, but I think I'm hopefully giving you a framework to understand the issues. Is it Heta?
Yes, sir. Yes, sir.
Yes, sir. Yes, sir. Sir, I had a question that how do you think that this whole decision would impact the international IP regime? And according to you, how would the World Intellectual Property Right Organization would deal with it?
Well, I think this decision is consistent with TRIPS. I mean, I think this is very interesting on many levels. Um, I don't think formally the court was concerned about its obligation, the U.S. obligations under TRIPS. I think it was analyzing it under U.S. copyright law, and that if there was some problem with U.S. copyright law, that's for the WTO tribunal or the member states to raise. But I think, by avoiding the copyrightability issue, and this is maybe another reason why, Justice Breyer, who wrote the opinion, is more international minded than some of the other justices. He's written about international law and the courts. The other justices probably are less concerned about international law than Breyer, or at least less mindful of international law. So one of the reasons for avoiding the copyrightability issue is to avoid the direct confrontation with the obligations under TRIPS. TRIPS does allow for exceptions under Article 13 and limitations, and other than academics, and there have only been a few articles like that I've seen. Really, maybe I don't want to. I'm not trying to dismiss those articles, but other than those articles, there has not really been any serious challenge to U.S. fair use law as conflicting with TRIPS obligations. So, this is where you get into some very interesting international law issues. On the one hand, I think the court, if you're trying to think about it, frame the decision in terms of U.S. obligations under TRIPS, it may have been written the way it was in order to avoid a direct conflict with TRIPS. It does raise the question, at least for some people, as to whether fair use under U.S. law is consistent with TRIPS, but that may be just a minority view, but it may be a growing minority, but it does raise some interesting question about the extent of exceptions and limitations more broadly, within the TRIPS agreement. So, for example, would this hold under fair dealing? I don't think this would be found to be fair dealing, but perhaps fair dealing should be expanded. I mean, there are some arguments that are being made that perhaps fair dealing should be expanded, or that if not an exact U.S. style fair use regime, but something similar to fair use. And something like that may already exist, it just may not have been implemented. Remember, fair use was a judge-made doctrine that goes back to some notion of privileged uses. So whatever the law of justification might be within within the common law system, perhaps there's a way for which fair use to arise organically, if not through statute. So I think it does raise a lot of rich questions, and your question is a very good one to point in that direction.
Thank you.
Good morning, sir. My name is Brijan Singh. So my
Yes.
question is, what does this decision hold for a country like India? Because if we talk about Android, which is an open source software and which has been modified by mobile companies by adding different layers. So how far the decision of Google versus Oracle would be applicable to India?
Well, I mean, Oracle I did not sue Google in India. I mean, the operating system is still there. I don't think. I think the answer is it'll be business as usual. I know. I don't know if people read Spicy IP, but there's an interesting post in Spicy IP a week or so ago, questioning Google versus Oracle. I recommend people read that post. That I can send the link if people have trouble finding it. It's very much worth reading in terms of the criticism. If I remember the post correctly, the post was basically saying that um, the APIs would be protected under Indian copyright law and would not be, wouldn't, and the infringement would not be protected by fair dealing under Indian copyright law. I don't know of many opinions, from the High Court or from the Supreme Court on software copyright in India. Of course, software patent is a different matter, and that's a very interesting part of this decision that I hinted at is that relationship. If you remember, this started out as a patent case, and the federal, within the federal circuit, the patent was invalidated. But there seems to be an underlying logic in the federal circuit that this software, if it's not protected by patent, maybe it should be protected by copyright. I mean, the obviously that is a false dichotomy. Maybe the software is not protected by anything, or maybe it's protected by trade secret in a different manner. Um, so I would recommend that you look at the Spicy IP post, which does suggest that APIs would be protected under Indian copyright law. There's not the similar exceptions as noted in the ECJ opinion in SAS or under 102B in the US Copyright Act. So, if Oracle wanted to pursue Google in India, perhaps it could, though it'd have to deal with Indian courts, and I don't want to get to that at this point. But so that would be my response. It would be interesting to see how the Indian courts deal with software copyright. There is a lot of skepticism about patenting software, and I think some of the skepticism about patenting software would extend to copywriting software as well.
Thank you so much, sir.
Thank you, sir, for your time and enlightening our students with this contemporary topic on intellectual property. Uh, any other further queries from any other participant? Okay, I don't think there are any queries. So thank you, today's speaker, Professor Dr. Shubha Ghosh, for accepting our invitation on behalf of Anand Law College and Anand College of Legal Studies. I uh, thank you, sir, for your time and for your effort in this particular topic. So I
Well,
would request now. Thank you, sir. Thank you. Yes, sir.
thank you for the invitation and thank you for the wonderful questions. And I very much enjoyed the time together and hope one day I can visit your campus when things are open again.
Thank you, sir. We are very eager to host you rather than
Yes,
virtually. It would be very good for if we host you physically.
yes, sir. Looking forward to see you, sir, in our campus, sir. Yeah.
Yes, and please keep in contact. If anybody has any further questions about this or other matters, please feel free to contact me.
So now I would request today's guest, Professor Dr. Shubha Ghosh, to kindly leave the session.
Okay, I will try to do so. Thank you again. Have a wonderful day.
Now I would request all the participants to kindly leave the session. The session is over.